I'm Carol Jones, and I'm a visiting scholar at the Environmental Law Institute and a co-author of the Asbestos chapter with Sandra Cham, who's going to present the second half of the overview, and with Cynthia Harris and Sam Koenig. I first wrote about the asbestos health crisis for my doctoral dissertation in the early 1980s. At the time, the new federal regulatory agencies, the Occupational Safety and Health Administration, OSHA, and the Environmental Protection Agency, EPA, were prioritizing regulating asbestos, but were facing headwinds from the industry. At the same time, the rules for tort liability were changing and courts were beginning to award compensation. Though much has changed in the past 3+ decades, asbestos remains a cautionary tale. Asbestos, which is actually a group of 6 minerals, is fire resistant and is highly malleable. As a result, it's been used throughout the 20th century to provide product safety in a wide range of products, though particularly in insulation for buildings and vehicle brakes. Though product safety was the goal, in fact, exposure to asbestos fibers causes serious impairments and diseases of the lungs and other organs. For 2 of the main diseases, asbestosis and mesothelioma, asbestos is the only known cause. However, many factors cause lung cancer, which is the major burden of disease. Because these diseases don't manifest for 10 to even 40 years after first exposure, the health risks were not readily apparent to workers. And furthermore, the industry suppressed information about the disease risk and ignored internal recommendations to adopt worker protections. It wasn't until the 1960s that independent studies documented the burden of disease in one of the buildings trades. Since then, as scientific evidence has accumulated, the consensus has arisen that there is no safe level of exposure. Yet exposures continue today because the federal regulatory system provides a patchwork of protections. Whereas virtually all industrialized countries have banned asbestos, even today in the US, we have only a partial ban. Slowed by industry lobbying, federal regulatory agencies have failed to set protective levels of exposure limits and to enforce those limits over the years. This series of business and government failures has resulted in exposures of tens of millions of people over more than a century. The result is a massive long-term burden of disease, disability, and death. And now I'll turn it over to Sandra Cham, who will talk about the legal developments in the asbestos health crisis.
I'm Sandra Nichols Cham, Associate Vice President of Research and Policy at the Environmental Law Institute. By the 1960s, more and more workers were falling ill. Workers' compensation programs had been in place since the 1910s, but they were designed to address workplace accidents, not occupational diseases that often manifested decades after a worker left a job. Victims turned to the courts, but still struggled to find relief, in part because of tort law's causation requirements. Epidemiological information is probabilistic and cannot show with certainty that any given exposure resulted in any given disease. Workers had been exposed to many different products in many different work sites, and in most cases, the exposures had been many decades before. Common law developments in the 1960s opened a pathway for these victims. In 1973, the Fifth Circuit adopted the doctrine of strict liability and allowed product liability for personal injury for an asbestos victim. Victims needed only show that they had been put in a dangerous situation, that the tort had occurred, and that the defendant was responsible. With a legal doctrine better suited to the reality of the risks of dangerous products, more and more cases were filed, but they were complex cases and parties were not motivated to settle. Soon, the courts faced a tidal wave of asbestos litigation that has become the largest and longest mass tort litigation in history. Courts tried various case management and consolidation techniques, including multi-district litigation. These approaches had some success, but none was really successful at efficiently and consistently providing relief. Because of the competing interests of all of the parties involved in these sprawling cases, the Supreme Court turned back efforts to use federal class action litigation as a solution. As liability against asbestos manufacturers accumulated, a new provision in the bankruptcy code allowed asbestos defendants to reorganize and continue to operate while limiting their liability to a set fund in an asbestos bankruptcy trust. These trusts have been plagued with controversy, but ultimately, they increased transaction costs overall and reduced compensation to victims. In an effort to get around the problems with the tort system, numerous proposals were brought before Congress to establish a universal compensation system, but none were ever passed. Tort law, in effect, became the only policy solution to address the multi-billion-dollar asbestos mass health crisis. The search for an equitable, efficient, and timely solution was never met. And even though age-adjusted death rates are down, people continue to suffer from asbestos disease and death.